Okay, so welcome everybody to Hands On. I am Alana. I'm the Operations and Events Manager at the Innovation Cluster. We are a not-for-profit organization that works with startups specifically working in technology. But with that being said, all of our workshops and events are open to the public, such as this one. We are also a part of the Team PTBO group, which includes some of the organizations that you're seeing on your screen right now. Also featured on your screen are some of our core partners. So again, thank you for joining us for this virtual hands-on, everything you need to know about incorporations with Lee from LLF Lawyers LLP. So some of the learning objectives for today are when and why you should incorporate, things to consider prior to incorporation, cost of incorporation and maintenance, as well as some information on the impacts of COVID-19. So for those of you who have questions, there will be a Q&A at the end of the presentation. I am going to enable the chat feature for you to ask your questions. And also after the session, we will be sending out a survey to hear back from you for you to let us know what you liked, what you didn't like, and what we can do to improve as well going forward. So I am going to pass it over to Lee now to get started.
Good afternoon, everyone. Thank you very much for the introduction, Alana. It's my pleasure to be able to give you this short presentation. I'm hoping to leave a lot of time for questions and answers, because I find then that way we can address your specific questions directly rather than me going around and about and telling you information that you may or may not know. So I'm going to start sharing my my PowerPoint here with you so you can see. And can everybody hear me well?
Yeah.
Okay, good. So just to give you a bit of my background, I have been practicing corporate commercial law in Peterborough for almost 7 years. Prior to that, I was at an international firm in Toronto for over 10 years, doing a variety of corporate commercial stuff like negotiating contracts, incorporating, structuring companies, financing, where companies and lenders need to document their loan transactions. I did a lot of cross-border work with US as well as multi-jurisdictional work, such as working in BC with counsel in BC and Nova Scotia. Also internationally, where at the tail end of my Toronto career, I was basically managing a lot of external foreign counsel all over the world to make sure that the transaction of our Canadian companies are completed and done properly. So this is a very basic workshop. We're talking about incorporation and what you need to know. So very simple stuff. If it's too simple, let me know and I can add more details, but this is just a preliminary information session for you so that you can turn your mind to what you need if you're thinking about incorporation. So a lot of people ask me, well, when should you incorporate and why should you incorporate? So when you want to incorporate is, especially for entrepreneurs, when you're starting out, is that you don't want to incur the cost of incorporation. You don't want to deal with the headache. But legally, a corporation is considered a separate legal entity. So what you need to do is incorporate in order to separate liabilities and also to make sure that you're protected as an individual, because your corporation is considered its own separate entity under the law. So a lot of entrepreneurs also would like to wait because they don't want to deal with the headache of incorporation. So I get a lot of questions about when do they want to incorporate? A lot of times because they need financing, where private investor or bank would require you to incorporate so that they know that you're serious about your business and they know that you have met certain legal requirements in order to deal with you. So that deals with the financing and the investment. Some people want to invest in a company because a company is a separate entity. It lives forever until dissolved by the shareholders. So even though they're investing on the, in the entrepreneur for their passion and their creation and their ideas, but they also want to have all of those transferred into the form of corporations so that they can invest in a corporation and take out shares. Other time, when you have a large contract where you're an entrepreneur is providing services or products, you also want to incorporate to limit personal liability. And also it lends to, it allows your other contracting party to it's usually a requirement that they enter into a contract with a corporation rather than an individual. So, you know, when you enter a large contract, it's usually because you have or you will very shortly launch a product or a service. So again, you want to do this in the form under a corporate entity rather than in your personal capacity. Same with the other reasons, partnerships with others, or if you think you are going to need employees, you generally would do it under a corporation where you would hire the employees, the consultant, or you decide to enter into partnership agreements with others. Okay, so why incorporate? One of the major reasons is because you want to shield your personal asset. Your personal asset belongs to you, and if you conduct business under your personal name, all of that asset is exposed. And as I've said before, a corporation is considered to be a separate legal entity apart from you. So if you incorporate, then you transfer some asset into the corporation so that, you know, like for example, intellectual property, then that the corporation then becomes its own entity after incorporation, and then you can conduct business on the limited basis rather than exposing all of your personal asset. There's also tax reason why you may want to incorporate. Generally, it's shielding personal liability and personal assets, and tax reasons why people want to incorporate. There are tax advantages and I guess lower tax rates for corporations. There's tax incentives. There are more grants available to corporations than individuals. So some of those are the reasons. The other reasons will be to add credibility and professionalism to your business, which relates to the first slide that I presented. And then to, you know, sometimes you have so many different services that you may want to subdivide, and you may want to say, you know, Corporation A holds the real estate, Corporation 2 holds certain assets, and Corporation 3 do the operation plus some other assets. So these are, you know, the main reasons why you want to incorporate. Other times, you know, you may want to say, you know, I'm in partnership, or I have other people that help me create a certain product. So I want to make sure the company that I've created with this person is limited to the product that he or she and I have created. And then I'm going to incorporate another corporation with somebody else because that person has helped me create a different product, or we're offering a different service. So these are the reasons why. Things to consider when you incorporate. It's very simple, but yet, you know, information gathering can be a bit of a challenge sometimes. So you need to have officers for the corporation. Those are people running the corporation. You need to have directors. In order to incorporate, you need to have a first director, who is a Canadian resident. In Ontario, particularly, there's a 25% residency requirement, which means if you decide to incorporate with 4 directors, then at least one of them have to be Canadian resident. For entrepreneurs, a lot of time it's just one director, in which case then you need that one director to be a Canadian resident. So generally, corporation, you can have one shareholder or you can have multiple shareholders. If there's only one shareholder, then you don't need a shareholders agreement. If there are multiple, we highly suggest that you enter into a shareholders agreement so that you know how each shareholder can exit. It also deals with how the shareholders want to operate the company, because some could be silent shareholders, some could be very active, some may have, you know, maybe actively employed with the corporation, while others do not work there at all, but yet they have invested. So there's many things that the shareholders agreement can cover. In case something goes wrong, then the parties know how they can extricate themselves from the corporation, and also, you know, how much they're going to get, or how will they get paid for their investment in their shares upon exit. So when we're talking about shareholders, there's different classes of shares that you can issue that have different rights. And so again, if you're an inactive shareholder, then maybe you want to hold preferred shares. And if you're an active partner who's putting your heart and soul into it, maybe you want common shares. So there's different types of classes of shares that you can have. I'm getting a little complicated here, but all to say, these are the things you have to think about. And so in order to incorporate, you have to have a name. So when you incorporate either in Canada or in Ontario, you're going to be assigned a corporate number. So if you want to be incorporated under a legal name like XYZ Airport Shop, Gift Shop, for example, then we would have to do a name search and then make sure that that name is available. If that name is not available because it is very common or there's an existing name that is out there already, then we would have to tell you, you have to drop this name or you have to change your name completely. A lot of time, if you're registering what's called a holdco, which means just a company holding shares of an operating company, then you'd probably want to have a numbered company. But if you have an operating company where you're more public facing, then you would want to have a named company. In Ontario, obviously you can incorporate in Ontario where your head office has to be located in Ontario, or you can incorporate in Canada and then register a specific head office address as well as where you want to do business. So if you register in Canada as a federal company, then you're gonna have to extra provincially register to do business in the provinces that you want to. So for example, in Ontario, in BC, those would be separate registrations. The location of your chief executive office would be Ontario if you incorporate in Ontario, and if you're incorporated as a federal company, you can make it Ontario or somewhere else or another province. And the things you want to consider, other things you want to consider would be government incentive in terms of, well, is one province giving more incentive than others? What are the tax benefits? So for example, if you're a Canadian controlled private corporation, which is called a CCPC under the Income Tax Act, then you have preferred corporate tax rate in comparison to what an individual would make if you were operating as a sole proprietor, earning say $200,000 a year. Your tax, the percentage of tax that you would have to pay as an individual would be a lot more than if you were a corporation. So I've touched on some of these before. So if you have multiple people as part of your company, say you're a group of 4, you develop a product or a service and now you want to incorporate, well, you really should get into a shareholders agreement, figuring out when and how each shareholder can leave and how they will get paid upon their exit. You will also need to think about employment agreements, perhaps for your employees, for shareholders who are employees, and potentially for other people that you do not engage on a full-time basis. So they could be independent contractors or consultants. So if you have employees, you have to make sure that you register for the proper, source deduction accounts with CRA. You also have to have your WSIB account. And as a corporation, generally, you would want to apply for your HST account so that you can be HST exempt for certain transactions. And the corporation, again, in terms of operation, you're going to need to provide your articles and your list of officers and directors to the bank to set up your bank account, because again, a corporation is a separate legal entity. And when it's conducting business, you should always think about getting insurance for your corporation, which is separate from your home, separate from what you do in your personal name, because again, the corporation is a separate legal entity. And then you have to think about, what are the maintenance costs when you incorporate? So annually, there should be a maintenance cost to maintain your minute book. A lot of people don't pay that, and then they sort of pay a catch-up fee at the end when they have to do a major transaction, like a financing or private equity funding, so that they can bring the minute book up to date. And then the cost to incorporate is not a lot in the bigger scheme of things. I know for some entrepreneurs, it could be a lot, but if you think about the benefits to incorporation, then the cost to incorporate, which is around, $1,500 plus HST to incorporate, is not a lot when you think about the long-term benefits. So I was asked to talk about the impact of COVID-19. And this is assuming you already have a corporation. So if you have a corporation and you're in trouble, a lot of companies have already had to lay off their employees, um, either permanently or temporarily. So you may have major contracts that, you know, you may not be able to fulfill. For example, supply contracts with overseas companies. A lot of those are sort of, you know, up in the air right now because the supplier cannot supply or cannot get products to you on time because of shipping delays, because of border closures. So that has a trickle effect on how you're going to deliver your services and your products to your end user and your customers. So it's very important to look at your contracts for termination clauses, force majeure clauses, to see if there's a way to get out with minimum penalty. I will say that for a lot of contracts, you know, a pandemic would not have been included in the force majeure clause, which is, you know, a natural act of God clause that will allow you to get out of your contractual obligation. So it's important for you to, if you're a corporation or even an individual, if you have a contract that that, you know, has financial implications, then you need to look at the termination clause and the force majeure clauses, and see what you can do. A lot of times I find that, you know, with the assistance of a third party, the contracting parties can come to a resolution. But you know, we're all sort of muddling through right now because it's uncharted times. Also check your insurance policy. As I've said, if you're a corporation or if you're acting even as a sole proprietor, you need to have proper insurance because you do not want to expose your personal liability. Then check your insurance, check with your insurance broker if, you know, your business has been down for 3 months and there's an income loss, if your business interruption coverage would help. I know there's some case law around it already, but it's not very clear right now. So obviously from the insurer perspective, they don't want to insure anything. And it really depends on the language in your policy about what they will and will not cover. So every insurance company is different. So you should check your policy or talk to your broker. And then if you have employees in your corporation, then you need to worry about what are your obligations as an employer during the pandemic and after. As I said, a lot of companies that I've been dealing with, they have laid off their employees so that they can access the CERB program, which is $2,000 per person per month for up to 4 months, I think. So the government may extend that, and as a result, there's a labor shortage. People do not want to go back to work, or they're afraid to go back to work because of COVID. So, you know, if you are thinking your business is going to continue, you need to make a contingent plan dealing with what are you going to do with employees that do not want to return? What are you going to do when employees do return, because you have to make sure your work environment is safe, and just, you know, deal with people's special circumstances and being sensitive to that. At the meantime, trying to rejuvenate and restart your business, which is a different challenge on its own. So the government, I know, has several programs to help small businesses. It's arguable whether it will help entrepreneurs, because they're, at least for the small business loan of the $40,000, I think there was a threshold that required the company to have a certain amount of payroll. I believe that has been recently changed, so that if you have a small business that I think had expenses versus just payroll expenses up to a certain threshold, I think $20,000, but don't quote me on it, then you can access the program. There are other programs. So as a corporation, there are more incentive, again, for grants and reliefs and loan programs from the government than if you were just an individual. And lastly, you know, your customer base is your bread and butter. So you got to think about, you know, what will happen to your company and its business if the customer base increases a lot or decreases a lot because of this COVID-19, and if there's going to be a second wave. So there's lots of things to consider, and, you know, even for liability purposes, you may want to incorporate now if you're thinking of starting a business or, you know, launching a product, because again, there's a lot of liability that you can sort of silo into the corporation because it's the corporation's business activity, rather than you doing it under your personal name as a sole proprietor and then incurring a whole bunch of personal liability that you're going to need to extricate yourself from if something bad was to happen. So I will leave it there and see if you have any questions, because I want to address your questions more directly.
Great. So if anybody does have any questions, please put them in the chat box. We actually already have one that was sent to me. So how long does it usually take to incorporate?
You saw the list of questions that I had, like things for you to consider. If you provide those information to us, you know, within a day of you asking us to incorporate, and say if there are multiple classes of shares that you need, then you let us know what their different rights attributed to each class of shares would be. Those are usually the more complex stuff that we have to deal with during incorporation. But if you incorporate a very simple one class share company with, you know, with 2 directors and 2 officers, that kind of thing, it can happen within a day or 2.
Right. And is there a difference between incorporating from a sole proprietorship versus a partnership?
You're going to incorporate, and the difference is that where you're transferring the asset from, whether it's from you personally or from the partnership. But once the incorporation happens, the company, you just create a new legal entity that's distinct and separate from the partnership and from the sole proprietor, so it doesn't matter.
Okay. The next question is from John. You mentioned minutes and a cost associated with that. Can you elaborate on that a bit more?
Yeah, so every corporation, when we set one up, you need to have a minute book, which stores all of your corporate proceedings. So that would include your articles of incorporation plus any amendments. It would include your corporate bylaws. It would include appointments of directors and officers, consents from them, your shareholder register, which lists, you know, who owns what shares, a shareholders agreement, if you have any, and then resolutions, which are from time to time passed by the directors of the corporation to, for example, to distribute dividends, to obtain a loan, or to admit new investors or shareholders into the company. So those are the major documents that would be maintained in your minute book. So for us at the law firm, we always get letters from accountants on an annual basis saying, you know, this type of shareholder got, you know, $2 per share distributed for the year end 2019, for example. So we would document that just to make sure, because as time passes, people forget, or, you know, if somebody exits the company and they got bought out and we don't know about it, and the proper resolution has not been passed, when a major transaction happened, like a financing or an equity injection or investment come in, all of that information would be inaccurate, and a lot of work has to be done to trace back. So we suggest that you update your minute book and keep all of your corporate proceedings current each year, so it's easier and more expedient when you do have a major transaction to conduct.
Okay, so the next question is from Charlie. What is the difference between a professional corporation and other corporations? I'm a psychologist. What benefits or problems would there be with either approach?
So a professional corporation, you need to have, in order to, sorry, let me step back. A corporation is a corporation. It's still a separate legal entity, but for certain professions, you are allowed to incorporate a professional corporation. And some people, for example, for lawyers, if we incorporate, we would have to be a professional corporation because the Law Society Act requires it. So generally, a professional corporation can only be owned by the professional, and so it allows you to operate as a corporation rather than in your individual capacity, and it helps you better in terms of tax planning. So the incorporation will be slightly different because there are certain things that you need to put in the articles for the professional corporation that you would not put in a normal for-profit corporation, but it's set up so that you can better tax structure as a professional.
Okay. The next question is from Rob. How big of an issue is it not keeping up with the minutes and meetings of incorporation ledger? Can you be fined?
No, you cannot be fined. We can always fix it. So we've seen minute books where they have not been fixed or maintained up to 20 years. So the challenge is, have the directors and officers been properly appointed and removed? A lot of times when for example, you get a large bank financing, you will you will need all of the current directors to approve the transaction. Well, do you know who are the current directors? And if it's very simple, that it was you who incorporated from the beginning, and it was only you who's the officer and director, and there's nobody else, and that has been going on for 20 years, then it's simple. But if you've had multiple people come and go, then it can be a challenge, because we will have to make sure we trace back, who resigned, who came on, in what capacity, when, and then we have to refile with the government, because corporations are supposed to keep their information as up to date as possible. But there's no particular fine.
That was actually the last question. Does anybody else have any that they want to pop in? Oh, all right. Any advice on vested shares when you bring on a co-founder? How long should the vesting period be? Any other protections needed to be considered in the contract? How do you get back the shares if the co-founder decides to leave?
So for shareholders, there's no vesting. What you're talking about is options, and particularly probably you're thinking about employee stock options. So employees are not co-founders, or well, they can be, but usually co-founders would be shareholders of the corporation. They would not be agreeing to taking options if they co-found the company with you. So I can address the stock option separately. Now, with respect to you incorporating a company with your co-shareholder, and then he or she wants to leave because of a disagreement or for whatever reason, that's what a shareholders agreement is for, because then you can determine how the exit will happen. So there's a lot of times, we have to deal with if there was a third party offer for his or her shares, or are you buying the shares back into the company, which is buying shares to be put back into treasury, or are you talking about them wanting to buy you, or them wanting you to buy their shares, and at what price, and how would the payment work out? Like, can you pay over time? Do you have to pay a one lump sum right away? So there are various arrangements that I've seen shareholders make among each other, and then we document for them. So generally, shareholders would just get shares in the same class of shares if they're co-founders. If not, then they get different class of shares, but very small difference. Again, it's more for tax and distribution purposes, which I can get into, but probably not the right context right now. So you want to make sure that you have a shareholders agreement if you have a co-founder. That's the bottom line. Now, with respect to the employee stock options, you can have different vesting periods. I've seen some where it will vest after 2 years of full-time employment, or after the employee meeting certain targets. So the vesting period is the period from the time that the employee is granted the option up to the time where he or she can then exercise those options and convert them into share. And so that during that time, that's the vesting period, and it really ranges, and it's whatever you want.
Okay. So the next question is from Scott. Generally, at what amount of revenue does it make sense to incorporate versus just operating as a sole proprietor?
I would say there is some revenue consideration. So, if you're making what you would make as a salary if you were working for somebody. So say you're making about, like $50,000 to $80,000 on your own as a sole proprietor. You may not want to, but if the service or the product that you're providing as a proprietor carry high risk, then it doesn't matter. I would recommend that you incorporate, because whatever you're earning as a sole proprietor, not only is it taxed differently, but you are exposing your personal assets. So if you own a home, that would be exposed. So it depends on a variety of factors, what you're doing, what services are you providing, and then, whether if you're doing $20,000, it's probably not worth a lot. But again, it depends on the service that you're providing. If it carries high liability, then I would still say you do it, or maybe you don't do that type of business.
Okay. So That was the last question. If anybody does have any questions after we close the session, feel free to email me and I can forward those questions to Lee. This was recorded, so everybody will have an opportunity to review it as well as get any materials associated with the session. I know that one of the attendees was asking for a brochure. Thanks so much, Lee, for participating today. We really appreciate your time. Do you have any closing comments to make?
No, I on my PowerPoint, I did put my email and my phone number. So if you have questions, feel free to send them to me. I'm pretty responsive, so you'll get a response. But I will have to say, this is the lawyer cover your behind thing, which is if I'm not, because I'm not retained by you, whatever, I guess suggestions I give you would be suggestions and not legal advice.
All right, thanks so much for attending, everybody, and thanks again, Lee.
Thank you.